A lot of our problems can be attributed directly to legislation that was once well-meaning and has now mission creeped its way into being something else entirely.
Coming up on British Thought Leaders, Michael Reiners talks about laws that are being repurposed to attack British freedoms. He says the Public Order Act is used to stop people talking about sensitive topics.
Heaven knows people think of that act, if they've heard of it, as an act to police riots and protest and prevent them transitioning into a riot. Not at all. A lot of it is really just going after people for speech offences.
That the ECHR is used to undermine domestic immigration law.
It's my view, and many others, that we should absolutely decouple from the ECHR and unbake it from our national legislation if we are ever to secure not only our borders, but a variety of other things.
Michael talks about the problem of judicial activism.
There's never been a time when we are more at sea when it comes to actually seeing our laws when a decision is challenged, landing in a completely different way to the way Parliament would have envisioned. Certainly in a different way to many of the public would have envisioned, and we're left asking why.
Welcome to British Thought Leaders. I'm Lee Hall. Today I'm sitting down with lawyer and author Michael Reiners. Michael, welcome to the show.
Well, thank you for having me, Lee.
You've written about how England is under attack. Before we get into the details, can you give us an overview of how this attack manifests?
So it's a bit of a hyperbolic name, but it's deliberate that it is. I'm talking really about our constitutional arrangement and the fact that it has been under attack and placed us in a state of constant attack since really about 1997, when it was reshaped from a previous constitution into what I see as a totally new constitution, as I put it in the article. And that happens in a number of ways. That attack has really been on Parliament and sovereignty in that way. And it comes in three forms, three directions, if you will, on that parliamentary sovereignty. In the first instance, it defers a huge amount of responsibility away from Parliament in the upwards direction, that is to supranational, European-wide type organisations. Blair, of course, was very keen to have closer union with Europe, went into all the treaties, Maastricht being under Major, sure, but ever closer union is definitely the name of the game from Blair's election on. And also, with the Human Rights Act in 1998, we have a deference to another European institution, not the EU, but the ECHR, the European Court of Human Rights. Distinct entities who don't get on, actually, but two ways of deferring parliamentary power away from the institution here at home. The ECHR is baked in to that act, and at Section 5 we have a complete ability to check on any piece of parliamentary legislation, and it acts as a regulator for parliamentary legislation. So this deference upwards is the first, and then outwards in the creation of about 400, what we might call now, and you see in the press a lot called quangos, but the bigger ones out there, most of the regulatory bodies that overlook professions, professional life, and speech within professional life are all created in that period. Now sure, many of these were sort of professional-led, pay a subscription fee type institutions, but they were all given legislative power backing them in the Blair era. And I see this as the horizontal type of attack, really, on our former constitutional freedoms. This basic sense that liberty is default without it being taken away from you. And here we have ostensibly regulators in everything from care work to the Bar of England and Wales having statutory backing to effectively limit your speech as a person in public life. The same to parliamentarians. And you see a weakening of Parliament as first we get the Parliamentary Code of Conduct under Major, but then added to significantly by Blair, and a similar thing happens there. You have to declare all your interests. Something to be said for that, but then that oversteps the line of it just being reasonable, checking in on the conduct of MPs, and starts to be, well, what can and can't you do before you're rejected from your position or face disciplinary action? And that's the same from doctors to nurses, from the Bar of England and Wales down to the Quality and Care Commission about what you can and can't say as a care worker sort of thing. That's the horizontal attack. And it keeps people from ever really veering out of this central, comfortable middle that people say elections can only be won from. It's not because the public are centrists, in my view. It's because you cannot enter public life without being one, because of these things. And then the third one, the downward part of that attack is devolution, the creation of the Greater London Authority Act 1999. You've got the Mayor of London, you've got the elected Assembly in London. That itself is one form of devolution. People often just think immediately of the various devolved powers to Scotland, to Wales and Northern Ireland, but no, not just that. We have things like that which set the framework for Manchester later down the line too.
So London kind of becoming a city-state almost.
Yes, so you've got two city-states there, with London being the earlier example. Now, the City of London, historic as it is, once you get past those dragons on the Thames outside Middle Temple, of course, that's far predating it, but this is a different political arrangement of the thing. Its intention, again, to take a variety of responsibilities away from Parliament and put them into the hands of people supposedly more able to diagnose local problems, but completely helpless to do so. And the same with Scotland, and the same with the various kingdoms having their devolved parliaments. A better diagnosis of the issue, but somehow it's somebody else's problem constantly. And this three-part attack, I would say, has weakened Parliament to the point of impotence, and those in it. And that's frequently reported by the kinds of MPs who, Rupert Lowe is a good example, who has been saying, can I get anything out of any of these ministerial bodies? And is this thing even functioning? And that's a frustration that I think a lot of MPs have, but quietly, and do not say it quite as vocally as Rupert in that instance.
So I wanted to dive into some of these acts and laws that have fundamentally changed things. The first one going back a bit, 1986 Public Order Act.
That's one I've been writing about lately, yes. And I just put an article out on it, because I think it's a bit of a sleeper, I wouldn't say hit, but a bit of a villain's charter in disguise. It sounds, and it's taught to police, like this act that is necessary to maintain public order. A lot of acts entrench themselves in this way, by sounding like they are absolutely essential to the well-oiled maintenance of any civilization, as we might recognise it in this country. Not so. It combines a few common law offences, riot among them, affray being another, violent disorder being a sort of a name attached to a variety of, any level of violence, be it ABH, GBH, in a sort of mass setting or in a protest-like setting. It bakes all those in. And then it proceeds from about there to invent all manner of offences based on someone taking offence or being threatened by offensive words. And then part 3 of it is the most egregious of all, and that's where we had the Lucy Connolly conviction, which we saw Alison Pearson in the Telegraph just this week, or I think it was last week now, sorry, saying, this is somebody who's had no priors, who's been convicted under this part of the Public Order Act, because they have said something which, while inflammatory, has the potential to stir in the minds of an observer racial hatred, and therefore should be treated with a 31-month prison sentence to make an example of this person, given that it happened in proximity, only in terms of time, to the riots of last summer. Now, there's no evidential link between the tweet that Lucy put out, who is a childminder and the wife of a Conservative councillor, no prior run-ins with the law, and a tweet angrily made having reacted to what is going on during the summer of last year following the Southport attack.
3.5 hours as well, wasn't it?
It was a very short amount of time, and Pearson's article goes into the much more human end of it. But my point is the legal one, and that is that it doesn't matter that anyone saw it and there was an evidential link to criminal activity. It doesn't matter that anyone was actually saying they were stirred to hatred. It was merely proximate to something that was happening independent of Lucy entirely. And by that logic, you could say that on September 11th, for example, suggesting after the first tower was hit that, goodness, I really don't like the World Trade Center. Who cares if another one of those happened? That would be a criminal offence because it happened immediately after in this country. That's the suggestion, and we're talking about imaginative criminal activity here. We're talking about the police inventing an observer to speech who can be stirred to hatred being enough to criminalise the speech without necessarily having seen it or been moved by it to action.
So does there have to be a victim who is saying that they're offended?
In this instance, no. Which is the most puzzling thing about it, I think, Lee, is that the Attorney General signed off on this one with the Lucy Connolly case. Somebody needs only to have reported it to police. They don't have to have been stirred to hatred. It just so happens that they will fit such speech to an offence like Section or Part 3 of the Public Order Act. Now, the other big one for speech offences is the Malicious Communications Act, which is to do with whether something is grossly offensive. But it does require it's communicated, usually directly, and that somebody has reported it as grossly offensive. It's gone beyond merely a joke. It's from the case law that it's gone beyond merely a joke in bad taste and now it is grossly offensive, wherever that boundary lies. That is entirely, again, to judicial discretion. But that, I think, is less intolerable than imagining a viewer is stirred to racial hatred, of course completely undefined in law, and certainly not the kind of offence I would expect your average jobbing copper to be an accurate appraiser of whether speech would stir somebody to racial hatred. And what is the sort of platonic ideal of a copper who can assess that? There isn't one. So it can be a very dangerously broad offence, that one, Part 3, and particularly Section 19, which Lucy was done under.
So we got to the point where it'd be quite difficult for these police officers. It's not a case of you've stolen something, that's an offence. It's now they've got to kind of get deep into the philosophy.
It bends credulity, doesn't it, that police would be even engaging in these kinds of hypotheticals. But at the end of them, there's not a hypothetical. There's somebody serving prison time, 31 months, and Pearson's article suggested that she is not being released early. They wish to make an example of her. And like I say, the Attorney General signed off on that one. Therefore, I think it's difficult to argue with the fact that that is a political use of the Public Order Act to make an example of somebody. And not enough people have been saying that. They've been a bit iffy about saying it because, oh, what a nasty tweet. But a tweet it is at the end of the day, Lee. It is not somebody going and committing arson. She didn't actually suggest in her tweet, you should go and do this. No, she said, I don't care if. And that is enough to therefore put you in prison for 31 months if connected to, I don't care if this happens. And that's extremely troubling and should be to anyone watching.
So sentences for people such as Lucy Connolly were heavier than some other sentences for people who did actual rioting. What does that tell us?
Well, I think it flies in the face of any normal observer who thinks, okay, a tweet, something that happens online, speech online, it is always taken, in my mind, and in many of my generation's mind, and I think in many ordinary people's mind, as less serious than shouting obscenity or whatever it may be to a person in the street. And now, having at least had a bit of my own time on the internet, in my own upbringing, in my own background and whatnot, and understood that culture, it's a culture of rough and tumble. And I've made the case that, a bit like the exceptions to assault that you get for jostling on the tube, packed tube, you're going to touch people, and therefore that's not sexual harassment outright, it's ruled out. It's not assault outright because you're in a packed tube. The internet should be given a similar exception, because prior to forcing everyone onto it in 2020 during the lockdown, where people who weren't native to the internet or that familiar with its customs, prior to that, it was a place where you would expect that kind of rough and tumble. It's the kind of place where you'd expect obscenity in a higher degree than you would in a cafe. And now I think people have come in, having not had that experience of living part in the internet world, and have thought, wow, I am really in a cafe, and this is a shocking experience. So I think the judiciary brings that view also, and we end up with sentences that treat it like anything said online was shouted across the floor of a cafe. And I don't think that that's the correct approach at all, and shows a fundamental misunderstanding of the culture of the internet, partly brought about by this exodus of people who aren't familiar with it, who were forced to engage with it as their sole means of communication after March of 2020. that's a big cultural shift, Lee. That's something that you don't normally get, where you get a group of people, in this case, the culture of the internet, and then you force in, by government fiat, an entire other group who isn't familiar with it. And the judiciary don't seem to understand this, and the people who are doing the reporting are usually those who aren't familiar with the rough and tumble. I think either ring fence it from things like the Public Order Act, or indeed make a blanket exemption for a lot of the kind of things that you would expect on the internet, but would be strange in person. No thought is given to that. Not in the Digital Harm Act either.
Do you think this Public Order Act is being used to maybe reduce some discussion of sensitive topics, perhaps the mass immigration impact?
I do think that the Public Order Act has made anything other than wholly positive commentary about ethnicity could be criminal under anything after Section 4 of that Act. That's a huge problem. That Act is from 1986. It wasn't made for the internet.
We didn't have internet then.
No. Well, apart from the American military and such, but they weren't using it to discuss mass immigration and the wayward nature of it in this country. So it didn't have mind to that at all. It was designed as an act to contain physical riots, and it's being used, and the numbers speak to it, to police that kind of conversation on the internet, as if it is a precursor and a precondition to riot, or, in many ways, is worse, as you see in the sentences. So, under the first 4 sections of the Public Order Act, no riots took place that year, okay. However, about 350 people were prosecuted under violent disorder, but a few hundred people. And then for the offence-taken, speech-related offences of the Public Order Act, about 10,000 people.
10,000?
Yes. So orders of magnitude beyond just looking at physical disorder. Now, many of those offences will have been in person. They won't be just digitally done. But they are effectively speech offences. Heaven knows people think of that act, if they've heard of it, as an act to police riots and protest and prevent them transitioning into a riot. Not at all. A lot of it is really just going after people for speech offences, and that is something that I just can't stress enough with that act, and have been quite critical of it for that reason.
How would you describe the status of free speech in Britain at the moment?
I think in the minds of someone like me who has been looking at this stuff, very dire. Once you're acquainted with the sort of things that could be used against you, for example, Digital Harm Bill, the 2023 one came in under Sunak, or was given royal assent under Sunak, actually criminalises April Fool's jokes.
Really?
Yes. Now, I joked about this on April Fool's Day. I said, I know better than to do an April Fool's because a section of this act prevents you from using any kind of information which you know to be untrue and sharing it online without reasonable excuse. And I didn't want to be the first person in this country to argue that it being posted before 12 noon on April 1st was a reasonable excuse. That we shouldn't be in that situation, but it is entirely possible that you could be prosecuted for an April Fool's joke, should someone want that to happen to you. And that's a big if, really, Lee. It's the should someone want that to happen to you with a lot of the speech law, which makes it so grim, is that people can report you for all manner of speech, and the police will find an appropriate act to fit that speech. The Malicious Communications Act, Public Order Act, now the digital harm stuff, and anything that could be construed as assault, immediate threat and that kind of thing. We've got a lot of things, a Swiss Army knife, if you will, of things that can be used against you, but it requires someone to report you in this aggrieved way. And I would say frequently that is just activists at this point. Very few of those reports are going to be, I've seen this tweet, I'm so horrendously moved and psychologically affected by it that I must call the police. No, it'll be, I don't like this person and I don't like what they have to say.
We talked about there being no victim. There can also be no crime. We now have these non-crime hate incidents that people can get reported for.
So I mentioned Alison Pearson, who's been very big on the Connolly case and reporting on that, the human side of that. Now, Pearson had a non-crime hate incident reported against them, and they weren't sure what it's for. All they knew it was going to be sort of accompanying their non-existent criminal record in the National Police computer, a knock on the door, some implication that they have said something recently or perhaps not recently that needs to be reported as a non-crime or recorded as a non-crime hate incident. Now, this is the same thing we had with Harry Miller, and that case concluded in 2021, where he had challenged a similar thing. And the non-crime hate incident thing is very troubling. It has a chilling effect, obviously. Anyone who gets a call from the police, even if they're not giving you a caution, they're giving you something just before a caution. Maybe something more akin to a middle-class caution, in Alison Pearson's case. And it's good that that is getting more attention, and the Miller case came out in favour of Harry, who was a chap he posted a limerick, a Lincolnshire policeman who had posted a limerick, and then he won the challenge of that being recorded on his National Police computer record. Alison's articles from last year touched upon, what is this? Why do I have no ability to know what it is I've said, and therefore I can't speak to or defend this strange non-offence being recorded against me? It's mystifying to people, and so are many of the Public Order Act offences too. You see all kinds of videos of people being, given a dawn knock on the door for things they're uncertain as to why about. But it's once you know which are the sort of seemingly evil pieces of legislation that are being used to chill people's speech, and I use that word deliberately, chilling effect on speech. It appears a lot in case law that if an action has a chilling effect on speech, well, that would usually be in contravention of their ability to speak freely. And the non-crime hate incident stuff certainly does.
Moving on to another law that we keep seeing in headlines a lot now, the European Convention on Human Rights. So we ratified this in the 50s, and then it became part of our UK law in 1998 with the Human Rights Act. Can you help us understand what impact this has had on our nation?
So this one's an interesting one, Lee, because we are the first to ratify that treaty as an agreement between 12 European states that we will never go to war with each other like the horrors of the Second World War. We will litigate and mediate like a marriage counselling facility for these various neighbouring states. And we will ensure that we go about ourselves like that from now on and never again. And all that. Perfectly sensible. I don't think anyone would dispute that. Then in the 70s they said it's not just 12 states can make appeals to this court or can make petitions to this court. We're going to expand that to the entire population. We accept that in the 70s. And then the court said we have such a vast backlog it will take about 50 years to get through it. That was in 2011. And most states, after having given the ECHR as an institution separate to its signatories, after giving individual petition from those various nations, also baked the ECHR, the treaty, into national law, as we did in the Public Order Act, in the Human Rights Act of 1998. That is again to try and stop that caseload getting bigger. It's in 2011 that the court said it has about a 46-year backlog, I believe. Cameron makes the Brighton Declaration that we're all going to pursue this policy of subsidiarity to help it with its caseload and deal with it at a national level. And we're going to use things like the Human Rights Act, and we should all have one of these.
So is that local judges carrying out
essentially that's trying to stop any of that reaching the central court by dealing with it as far as you can in national courts and interpreting national legislation that could be in contravention, it could lead to a petition as much as possible to be compatible with the ECHR rights. Now, realistically what that's happened is it's made our immigration tribunals completely porous. Because in trying to stop anyone having a petition to the central court, we've said, well, we'll interpret everything as broadly as possible, make sure that everything is fully within these rights. The net effect of which is that we end up taking a huge amount more people who have claimed asylum or have claimed humanitarian aid reason to be here. In our immigration tribunals in particular, and upper tribunals, we're setting all kinds of legal precedent that interprets national law as widely as possible to be compatible with ECHR rights. only because this court has expanded so grotesquely beyond its purpose of being a 12-nation mediator court to being a 820 million person. That's the amount of people who could petition it. So that expansion is way beyond the never again, let's not fight World War II again. That's a gross enlargement of duty that, for some reason, because of the never again point of isn't it nice to litigate between nations instead of going to mechanized, horrifying levels of bloodshed in Europe, that has then facilitated us assisting a Central European court, the ECHR, in removing any of our borders, really. Because if you can come in and claim these rights should be applicable to you as a universal human, as somebody who is a human and therefore present in a state that is a signatory, you can tell that state, you have to interpret your own laws as broadly as possible to accommodate me because I'm human and I'm here. Effectively, it's gone from the aversion of war mediator to something that has made the prerequisite to citizenship simply being human and being present. And I can see no defence for that. It's my view, and many others, that we should absolutely decouple from the ECHR and unbake it from our national legislation if we are ever to secure not only our borders, but a variety of other things that would require us to forgo them if we were to interpret our own laws as broadly as possible in ECHR right terms.
Kemi Badenoch said that migrants are weaponizing the ECHR. Can you explain that for us? Give us some examples.
So, a 2007 Act gave our immigration tribunals the ability to make binding case law, and a very good example of somebody using that ability in the upper tribunals, immigration tribunals, specialist tribunals for these kinds of things. A very good example is Judge Norton Taylor using the Ukrainian resettlement scheme to allow a Palestinian family to enter the country and to stay under Article 8 of the ECHR in an upper tribunal, which is now a binding precedent. Now that scheme is gone, so there won't be any other Palestinian families, to my knowledge, under a scheme that is now no longer functioning. But there's an example of something that any ordinary person would think, what? How's that managed to be? Yes, and that is now a binding piece of law. So we didn't have that prior to 2007. There was a reshuffling of which was the appeal court, and now it's the upper tribunal. It used to go straight to an ordinary all-purpose court. Now you can create specialist case law in an upper tribunal, again, specialist to immigration. I think the effects of that have been that now it's endless application of ECHR laws in this sort of magic 8-ball way that it will conjure a reason for somebody to stay, and then with the ability to create those to make those decisions national case law too. Badenoch's completely correct to say that that's being abused, because we've got such an array of case law and an array of specialist immigration solicitors who are happy to use that case law. We've become completely porous because of it. And Badenoch's suggestion that we can disapply the ECHR and the Human Rights Act to specifically immigration cases doesn't go far enough at all, because, as I've just suggested, any other walk of life, it is extended far beyond its purpose, the ECHR. Any other area of law, again, it is expanded far beyond its purpose. Why just immigration then? Okay, you could say it's a moderate position, but if you're in the position of disapplying your own laws in order to make one sort of tribunal function, well, you have a bit of a problem, I think. And you should probably look at repealing or at least amending the laws that have got you there. I don't think disapplying would be nearly far enough with that.
The judge that you talk about there, who brought in the Palestinian family based on the Ukrainian family settlement law.
Yes.
How do we understand that? Is it that the judge would feel that their hands are tied by the ECHR and they have to do that, or is it that they're trying to make a point?
That's a good question, and it's a difficult one to answer, going to the details of the judgment. And it's not necessarily that they're attempting to set precedent with this in any proper way. I think it's more that this is activist behaviour or judicial activism from somebody who has a history of associating with the causes, who would the sort of causes that would explain an outcome that flew in the face of, it's the last thing Lord Denning would have wanted. To say, we're going to use this scheme for one thing to do another thing. I think the common factor is that that particular judge had a history of activism for the cause of essentially Palestinian resettlement.
You use the phrase judicial activism. It's become a bit more popular recently. I mean, laws in Britain are set by Parliament, but if a judge can create laws or override the will of Parliament, what does that say about our sovereignty and our democracy?
It says a lot about the kind of judges that we're training and the kind of things we're teaching people who end up in law school, end up going on into judicial selection, what we tell them about parliamentary law. And that is that really the role of a judge is to interpret and bend that as much as possible. Now, as a bit of an aside, the American Constitution would fall apart if it wasn't for the kind of conservatism that you see from a lot of the judges in their Supreme Court. It would completely come apart at the seams, and it would only take one stacked court of judicial activists, so to speak, to unmake that Constitution functionally. We have that same problem, except we've already gone beyond the pale with it. We've got judges who are taught that you should, of course, interpret everything in interesting ways that take into account ECHR rights and take into account now, in some of the upper courts, EU law as well. So you're dealing with a variety of jurisprudence that an excited and I would say innovative and perhaps even legislatively minded judge who is planning to legislate from the bench can do all kinds with, completely run amok with. So domestic case law, ECHR case law, and then absorbed and retained EU law. There's never been a time when we are more at sea when it comes to actually seeing our laws when a decision is challenged, landing in a completely different way to the way Parliament would have envisioned. Certainly in a different way to many of the public would have envisioned, and we're left asking why. I think it's that we teach lawyers just from the get-go that this is part of the exercise of being a lawyer, is to just find all these inventive ways of twisting and contorting laws and ignoring whatever Parliament has to do, looking on a case-by-case basis how to contort them more and more. And people are just completely aghast at this. But we're looking at about 3 bodies of law that can be applied to any decision now in upper courts. And that explains how we end up getting so deviated from parliamentary law. An act is an act, sure. It's our highest form of law in this country. It can be made by orders in Privy Council or by a parliamentary majority, and you don't mess around with it. It's our highest law. Once it's received royal assent, that's it. But once you then mix in domestic case law, ECHR case law, and the retained European law that we've got, you've got a problem because it's competing with all kinds of things. And the judicial activism point, and the phrase judicial activism, isn't so much that they're an activist willing to sit in the road, literally or figuratively, but they're an extraordinarily active element of the way in which laws are applied. Now, there's a bit of sitting in the road in some instances, but it's that they are way more activated than they should be in figuring out how a law should work.
It seems an ongoing theme with this is mission creep, if you like, a law or an act straying from what it was originally for to become something quite different.
Yes, and mission creep's a good word for it. I think with the ECHR point, you've got a very good example of mission creep. With the Public Order Act point, you've got another good example of mission creep, something disguising itself as an act to prevent riots that ends up in orders of magnitude mainly dealing with speech. And then another good one is with the European Convention of Human Rights being baked in 1998 in the Human Rights Act. It sounds very cuddly, and it sounds like this thing that would almost enshrine your very existence, your ability to drink water and breathe air. And many people do believe that, but an act like that has sort of enshrined a lot of mission creep. The ECHR had already had mission creep. It went from 12 to 820 million, people who can petition it. The ECHR is then baked in after that has happened, and it's called something so cuddly and wonderful and apple pie and all that you would never want to repeal it. I think that's entrenchment. The press would go insane if you tried to repeal the Human Rights Act. They'd erupt, of course, if you were going to say the Human Rights Act goes. Even Farage and people who are completely adamant about leaving the ECHR like the fact, Jemrick calls it the ECHR. He doesn't go on about the Human Rights Act much because it's this sort of soulless initialism, whereas the Human Rights Act people get upset about. What they should know, though, I think, Lee, is that the Human Rights Act, and particularly Article 2 of the ECHR, were used to facilitate the largest suspension of human rights in British history in March of 2020. And it was deemed compatible with domestic law that was done. And it was deemed compatible with ECHR case law. It was ruled academic because the Johnson government had got the Coronavirus Act in and changed the law in the time the appeal was occurring. Simon Dolan was the one who brought the appeal, and it reached the Court of Appeal, and it was effectively ruled academic because a new act had been brought in to justify the thing. I think people ought to know that one a little bit more broadly, that this cuddly thing that can never be repealed or we lose our human rights is responsible for the largest suspension of human rights in British history, in my view. And that was compatible with it.
Another interesting ECHR case that I wanted to bring up with you. Some British lawyers are appealing to the Home Secretary to remove the designation of Hamas as a terrorist organisation. This is Hamas who carried out the worst terror attack in Israel's history in less than 2 years ago. Are we in danger of seeing our human rights laws give priority to foreign terrorists over our own national security?
I think this one's particularly uncomfortable because you've got somebody on the roll in England and Wales, a variety of lawyers on the roll here, serving the interests of foreign powers whilst operating in our jurisdiction and still fully allowed to practice. There's been all kinds of spats between people reporting each other to regulators for positions on the Palestinian-Israeli conflict, but in that particular instance, you've got people pursuing work clearly from an interested perspective to remove a terrorist designation from a group that has carried out countless atrocities. I think that's a sincere problem for, in their instance, the SRA, the Solicitors Regulatory Authority, and I'm in no favour of people's speech being policed there, but having a whole law firm pursue an alteration in terrorist designations for politically interested reasons is troubling, to say the least.
So, say you're given magical powers, you're now in charge, you can change anything to try and fix this situation. How do we do it?
Well, first three things to go. Equality Act, which is another cuddly act. A series of acts lead to it, and it's sort of the product of a variety of 60s and 70s acts baked in 2010. That goes. Public Order Act, that also goes. We return those offences to common law. The third one, I think, would be the Human Rights Act. It has done almost nothing to secure those rights, I would say, at the times that we need them. Lockdown being the operative case. And the ECHR itself is drafted in such a way that it gives you the right to live, Lee. Which sounds great, but nobody should be giving you the right to live. All of the rights contained therein are granted as a beautiful gift from the state. That's the opposite of the way that the US Constitution gives them. It guarantees them by non-interference from the state. So that one goes. We need to seriously then rethink about how those liberties are secured in a more case law-oriented way and how they are non-interfered with by the state rather than given to you by it. Because they can be taken away just as easily as they were in 2020 if we don't.
What would be the challenges if we did try and do those things?
The big challenge is that people have this sense that you need to replace it with something. You have to replace it with something. Usually the people who, in the human rights realm, want you to replace it with something are academics who've spent their entire careers writing about the Human Rights Act and indeed the ECHR.
So on a Bill of Rights or something like that?
Yes, and the Bill of Rights consultation that happened a few years ago, it was a complete failure for one reason. You don't have to replace it with anything, and you're going to have a very fruitless time figuring out what to replace something you dislike with when you don't even think it needs to be there in the first place. That's why we never got a Bill of Rights out of that. And I don't think we should be getting one in the style of New Zealand, because New Zealand's Bill of Rights is just the Human Rights Act. Like almost down to this exact wording. It's just the Human Rights Act as we have it here. It seems, in fact, that a lot of the way that that is constituted, that act, is straight out of New Zealand. So a Bill of Rights like that, for example, totally meaningless. And Dominic Raab having the fruitless task of having to figure out how do we get a Bill of Rights that sort of looks like New Zealand's or something. Well, that's exactly what he was trying to replace in the first place. I say there's no need for that.
You feeling optimistic that we can move things in the right direction for this?
I feel extremely optimistic that educating people on the pieces of legislation responsible for the things that they question in their lives is always going to be a good thing. And it's very unlikely that they're going to then defend them once they've seen them in the cold light of day. A lot of our problems can be attributed directly to legislation that was once well-meaning and has now mission creeped its way into being something else entirely.
Michael Reiners, thanks for joining us.
Thank you, Lee.